The moment I hammered the 20-foot flagpole into my front yard, I knew it would cause a stir in Oakwood Estates. What I didn't expect was that it would lead to an 18-month legal battle that would nearly cost me my home and sanity. I'd moved to Springfield, Missouri just 6 months earlier, looking for a fresh start after my divorce. The neighborhood seemed perfect, well-maintained homes with manicured lawns, a community pool, and friendly neighbors who waved as I jogged past their driveways in the morning. The house itself, a modest 3-bedroom colonial with blue shutters, felt like more space than I needed, but the price was right, and I figured I could grow into it. My name is Samuel Foster, but everyone calls me Sam. At 42, I was starting over, something I never thought I'd be doing at this stage in my life. 20 years in the Air Force had given me discipline, purpose, and a deep appreciation for the American flag. When I retired and my marriage fell apart almost simultaneously, that flag became even more important to me, a symbol of the country I'd served and the freedoms I'd fought to protect. The flagpole was delivered on a Tuesday in April. I spent the entire day setting the concrete base, making sure it was perfectly level before attaching the pole. By sunset, the stars and stripes flew proudly above my lawn, gently flapping in the spring breeze. I stood back, cracked open a beer, and felt at home for the first time since moving to Oakwood Estates. That feeling lasted exactly 17 hours. At 11:03 the next morning, my doorbell rang with an urgency that suggested either an emergency or an extremely impatient visitor. When I opened the door, I found myself face to face with a woman I'd seen at a few HOA meetings but hadn't formally met. She wore a pink cardigan despite the warm weather, her blonde hair cut in what I'd later learn was called a reverse bob, and her lips were pursed in obvious disapproval. "I'm Karen Whitfield, HOA president," she announced, extending a hand adorned with a massive diamond ring. "We need to discuss your addition." I shook her hand briefly. "Sam Foster, I assume you mean the flagpole," she nodded curtly. "Mr. Foster, Oakwood Estates has very specific guidelines about lawn ornaments and structures. Your flagpole exceeds our height restrictions by approximately 15 feet, and it wasn't approved by the Architectural Review Committee." I gestured to the flag. "It's the American flag." "I served 20 years in the Air Force. Surely there's an exception for the rules apply to everyone, Mr. Foster," she interrupted, her voice rising slightly. "No exceptions. I've brought you a copy of our covenant." She thrust a thick binder at me. Page 47, Section 8, Paragraph C clearly states that no structure may exceed 5 feet in height without prior written approval. I took the binder but didn't open it. "I'll review it, but I'm not taking down that flag." Her smile tightened. "You have 72 hours to remove the flagpole, or the HOA will begin issuing fines of $100 per day." She turned to leave, then paused. "Welcome to Oakwood Estates, Mr. Foster. I hope we can resolve this amicably." As she walked away, I noticed several neighbors watching from their windows or front porches. A few quickly looked away when I caught their eye. That evening, I pored over the covenant. Karen was right, there was indeed a 5-foot height restriction on all auxiliary structures. But something didn't sit right. I'd seen plenty of basketball hoops in driveways that were clearly higher than 5 feet. And the Johnsons 3 doors down had a massive satellite dish that had to be at least 8 feet tall. I called my old Air Force buddy Oliver Mitchell, who'd become a lawyer after his service. "Sam, buddy, how's civilian life treating you?" His voice boomed through the phone. "It has its challenges," I replied, explaining my situation. Oliver was quiet for a moment. "There's actually federal protection for displaying the American flag. It's called the Freedom to Display the American Flag Act of 2005. Basically, it says HOAs can't prohibit residents from displaying the flag, though they can impose reasonable restrictions. Is a 5-foot height limit reasonable for a flagpole, honestly? No. Standard flagpoles are typically much taller, but HOAs can be stubborn. Send me that covenant and I'll take a look. The next day, I received a formal violation notice slipped under my door. It included photographs of my flagpole from multiple angles and a reminder about the 72-hour deadline. At the bottom was Karen Whitfield's signature. The letters pressed so firmly into the paper that they created indentations on the back. I decided to attend that evening's HOA meeting to plead my case. The community center was packed apparently. News of my flagpole rebellion had spread quickly. I sat in the back row, noticing how several people turned to look at me with expressions ranging from curiosity to outright hostility. Karen called the meeting to order promptly at 7 p.m. After covering several agenda items about landscaping contracts and pool maintenance schedules, she reached the open violations section. And now, regarding the unauthorized structure at 1742 Oakwood Drive, she said, her voice carrying easily through the room. Mr. Foster has installed a flagpole that violates our height restrictions. The board has issued a formal notice and expects compliance by Friday. I raised my hand. May I speak? Karen's lips tightened, but she nodded. You have 2 minutes, Mr. Foster. I stood, suddenly aware of how many eyes were on me. I understand the importance of neighborhood standards. I really do. But this isn't about aesthetics, it's about patriotism and honoring our country. I served 20 years defending the flag. I'm now being told I can't properly display. A few murmurs of support rippled through the crowd. Moreover, I continued, federal law protects my right to display the American flag. The Freedom to Display the American Flag Act specifically prevents HOAs from prohibiting residents from flying the flag. Karen's face flushed. We're not prohibiting the display of the flag, Mr. Foster. You're welcome to mount a flag on your porch like everyone else. We're simply enforcing our height restriction on structures. A restriction that seems selectively enforced, I countered. There are basketball hoops and satellite dishes throughout the neighborhood that exceed 5 feet. The room grew uncomfortably quiet. Karen cleared her throat. Those items fall under different classifications in our covenant. Your 2 minutes are up, Mr. Foster. The board's decision stands. As I returned to my seat, an older gentleman in a Vietnam veteran cap caught my eye and gave me a subtle nod of support. After the meeting, a woman approached me in the parking lot. I'm Olivia Matthews, she said, extending her hand. I live on Sycamore Court. For what it's worth, I think your flagpole is perfectly fine. Olivia was about my age with auburn hair and kind eyes. Thanks. Apparently, I'm the only one who thinks so. She shook her head. Not true. Karen just has everyone intimidated. Last year, she forced the Hendersons to remove their children's treehouse because it was an eyesore. The thing was barely visible from the street and brought those kids so much joy. How does she stay in power if everyone dislikes her? Low attendance at voting meetings, Olivia explained. Most people just want to live their lives without conflict. Karen shows up with her supporters and maintains control. She hesitated, then added, be careful. She can make life difficult for people who challenge her. As the 72-hour deadline approached, I received calls from Oliver. He'd reviewed the covenant and confirmed my suspicions. Their restriction is unreasonable, he said, and you're right about selective enforcement. That's a key weakness in their position. If they're allowing some structures over 5 feet but not others, that's discriminatory application. So what should I do? Don't take down the flagpole. Let them start issuing fines, but don't pay them yet. Document everything. Take photos of other structures in the neighborhood that exceed the height limit, and let me see if I can find similar cases for precedent. When Friday arrived, I didn't touch the flagpole. By noon, Karen Whitfield was back at my door, this time accompanied by a thin man in a polo shirt who she introduced as Douglas Perkins, the HOA treasurer. "Mr. Foster," Karen began, her voice clipped, "your compliance period has expired. As of today, the HOA will be assessing daily fines of $100 until the violation is corrected." I nodded politely. "I understand your position, but I believe my flagpole is protected under federal law. I won't be removing it or paying fines that contradict my rights as an American citizen." Douglas looked uncomfortable, shifting his weight from foot to foot. Karen's face, however, turned an alarming shade of red. "This isn't about patriotism, Mr. Foster," she hissed. "It's about following rules that everyone agreed to when they purchased property in this community. Your military service doesn't exempt you from civil obligations." Her words stung, but I kept my composure. "I respectfully disagree with your interpretation of the covenant and believe the HOA is selectively enforcing its rules. I'm prepared to defend my position legally if necessary." Karen's eyes narrowed. "Do you have any idea how expensive that would be? The HOA has legal resources that would bankrupt you before we even got to court." "Is that a threat, Miss Whitfield?" "It's a reality check," she replied before turning sharply and walking away, Douglas trailing behind her like a reluctant shadow. That evening I received a text from Olivia. "Heard about your standoff with Karen. Need anything?" I invited her over for coffee the next morning. She arrived with a box of donuts and a surprising amount of information. "I've been documenting Karen's selective enforcement for years," she explained, pulling out a folder filled with photographs. Basketball hoops, satellite dishes, pergolas, all technically over the 5-foot limit, all approved for certain residents. "Why have you been collecting all this?" Olivia sighed. 3 years ago, I wanted to install a small greenhouse in my backyard. Karen denied my request, claiming it would be an industrial eyesore. A month later, her friend Brenda Peterson got approval for an almost identical structure. That's when I started paying attention. As we spread her documentation across my kitchen table, patterns emerged. Residents who were friendly with Karen or who had professional connections she valued seemed to get exceptions to rules that were strictly enforced for others. "This is incredibly helpful," I told Olivia. "My lawyer friend thinks selective enforcement is our best argument." She smiled. "Our argument, so I'm part of the resistance now, if you want to be. I could use an ally who knows the neighborhood dynamics. Count me in. Someone needs to stand up to her." The daily fines began accumulating. Each morning, I found a new notice on my door detailing the growing amount I supposedly owed the HOA. After 2 weeks, the total had reached $1,400. Then, the psychological warfare began. Karen started organizing community walks that would conveniently pass by my house multiple times a day, with participants giving pointed looks at my flagpole. My next-door neighbors, the Richardsons, suddenly became cold, no longer waving when I collected my mail. I received an anonymous note in my mailbox suggesting I was un-American for causing community division, the irony of which wasn't lost on me. The isolation was wearing me down, but Olivia's support kept me going. She introduced me to other residents who shared their own stories of Karen's tyrannical rule. We began meeting regularly, sometimes at my house, sometimes at local coffee shops, strategizing ways to stand up to the HOA. 1 month into our standoff, I received a certified letter. The HOA was placing a lien on my property for non-payment of fines, which now totaled $3,000. I immediately called Oliver. "They're escalating faster than I expected," he said, concern evident in his voice. "A lien is serious. It could affect your ability to sell the property, or even lead to foreclosure if the amount grows large enough." "Can they really do this?" "Unfortunately, yes. HOAs have significant power in these situations. But I think we have enough evidence of selective enforcement to file a countersuit. Are you prepared for that step? It's going to get expensive and ugly." I thought about my retirement savings, the peace I'd hoped to find in this new chapter of my life, and the principles I'd fought to defend during my military career. "I'm in, Oliver. Let's fight back." The next day, Oliver filed our countersuit against the Oakwood Estates HOA, citing selective enforcement of covenants, unreasonable restriction of federally protected rights under the Freedom to Display the American Flag Act, and harassment. We requested an injunction to prevent further fines while the case proceeded. The news of the lawsuit spread through the neighborhood like wildfire. Olivia reported that sides were being taken, with some residents openly criticizing Karen's handling of the situation, while others doubled down on their support for maintaining standards. 3 days after we filed, I returned home from grocery shopping to find a group of about 20 people gathered on my lawn. My first thought was that Karen had organized some kind of protest against me. But as I pulled into my driveway, I realized many of them were wearing veterans' caps and patriotic clothing. A man stepped forward as I got out of my car. "Mr. Foster, I'm Jim Thompson, VFW Post 639. We heard about your situation and wanted to show our support." I was speechless as he explained that local veterans had organized a flag support rally at my house. They had brought lawn chairs, coolers of drinks, and American flag pins that they were distributing to supportive neighbors who stopped by. Karen arrived within 30 minutes, accompanied by 2 members of the HOA board and a man she introduced as the HOA's attorney. She demanded that everyone leave, claiming the gathering violated noise ordinances and rules against public assemblies in residential areas. Jim Thompson, a former Marine who stood at least 6'4", smiled down at her. "We're having a peaceful gathering on private property at the invitation of the homeowner. There's no noise violation. You can measure it if you'd like, and we're not blocking any public access." The attorney whispered something to Karen, who looked increasingly frustrated. They eventually left, but not before she announced loudly that this would all be noted in the ongoing legal proceedings. The Veterans Support Rally lasted well into the evening. Neighbors I'd never spoken to stopped by, some offering words of encouragement, others just curious about the commotion. By the time everyone left, I had a list of 15 residents who were willing to provide statements about selective enforcement of HOA rules. Olivia stayed to help clean up. "This is turning into something bigger than a flagpole dispute," she observed as we collected empty water bottles and paper plates. "I'm starting to realize that," I replied. "It's about standing up to petty tyranny. People are tired of being bullied by someone who's supposed to be serving the community." The next week, our motion for an injunction was granted. The judge ordered that no additional fines could be assessed while the case was pending, though the existing lien remained in place. It was a small victory, but one that gave us breathing room. Karen's response was to escalate in other ways. The HOA suddenly discovered that my grass was a 1/4 inch too long and that my mailbox was not in compliance with approved designs. New violation notices began appearing, each for different minor infractions. Oliver advised documenting everything but focusing on our main case. "This is typical retaliation," he explained. "They're trying to wear you down with 1,000 paper cuts. Stay focused on the flagpole issue. That's where we have federal law on our side." As summer turned to fall, the legal proceedings dragged on. Depositions were taken, motions filed and countered. Karen's testimony was particularly revealing when pressed about other structures exceeding height limitations. She became defensive and evasive, claiming she couldn't possibly be expected to measure every structure in the neighborhood. The financial strain was significant. Even with Oliver charging me a reduced rate, legal fees were mounting. I dipped into my savings more than I'd wanted to, and there were nights I lay awake wondering if I should just give in, remove the flagpole, and move somewhere without an HOA. During one such sleepless night, I received a text from Olivia. "Check your email. Found something important." The email contained scanned pages from HOA meeting minutes dating back 5 years. In them, Karen had approved a variance for a 12-foot pergola at her sister's house within the neighborhood, explicitly acknowledging that it exceeded height limitations, but granting an exception for aesthetic harmony and family enjoyment. "This is exactly what we needed," Oliver said when I forwarded him the documents. "Clear evidence of selective enforcement for personal benefit. I'm submitting this to the court immediately." 2 days later, we received notice that the judge wanted to schedule an on-site visit to Oakwood Estates as part of her deliberation process. Judge Alina Simmons, a no-nonsense woman in her 60s, arrived on a crisp October morning, accompanied by clerks and attorneys from both sides. I watched from my porch as she methodically toured the neighborhood, notepad in hand, measuring tape extended by her assistant as they documented structures throughout Oakwood Estates. She spent particular time at Karen's sister's house, measuring the pergola and taking photographs. When she reached my property, she examined the flagpole carefully, then turned to address both legal teams. "I've seen enough to make some preliminary observations," she said. "Mr. Foster's flagpole is indeed higher than the 5-foot limit specified in the covenant. However, I've counted 17 structures in this neighborhood that also exceed that limit, including pergolas, basketball hoops, garden arches, and satellite installations. This suggests, at minimum, inconsistent enforcement." Karen, who had been following the tour at a distance, stepped forward. "Your Honor, those other structures fall under different classifications in our Judge Simmons held up a hand. Miss Whitfield, this is not the time for arguments. You'll have your opportunity in court." She turned to me. "Mr. Foster, is there a reason you specifically needed a 20-foot flagpole rather than a shorter one?" I explained that proper flag etiquette, especially for a flag of the size I was displaying, called for a pole of appropriate height. A 5-foot pole would mean the flag would either drag on the ground or be displayed improperly, which would be disrespectful. She nodded thoughtfully. "Court will reconvene next week. I'll review all the evidence, including what I've observed today." As everyone dispersed, Olivia joined me on the porch. "I think that went well," she said, cautiously optimistic. "I hope so. I just want this to be over." The following week, we gathered in the county courthouse. The room was surprisingly full. Many Oakwood Estates residents had come to witness the outcome, sitting on either side of the aisle like some bizarre neighborhood wedding. Judge Simmons entered and called the court to order. She spent nearly 30 minutes reviewing the facts of the case, the relevant covenant sections, and the evidence of selective enforcement. Then she turned to the federal law aspect. The Freedom to Display the American Flag Act of 2005 specifically states that a condominium association, cooperative association, or residential real estate management association may not adopt or enforce any policy or enter into any agreement that would restrict or prevent a member of the association from displaying the flag of the United States. While associations may impose reasonable restrictions, the court finds that limiting flagpoles to 5 feet in height effectively prevents proper display of the American flag according to established flag etiquette. Karen's attorney tried to interject, but Judge Simmons continued. Furthermore, the evidence clearly demonstrates selective enforcement of the height restriction throughout Oakwood Estates. The HOA has approved numerous structures exceeding 5 feet, including a 12-foot pergola for the HOA president's sister, while aggressively enforcing the restriction against Mr. Foster's flagpole. I held my breath as she delivered her ruling. The court finds in favor of the plaintiff, Samuel Foster. The Oakwood Estates HOA is ordered to remove the lien on Mr. Foster's property, cease all fines related to the flagpole, and permit the continued display of the American flag on said pole. Additionally, the HOA must review and standardize its enforcement procedures to ensure consistent application of covenant restrictions to all residents. Relief washed over me. Olivia squeezed my arm, and several veterans in the audience nodded approvingly. Karen sat rigidly in her seat, her face a mask of controlled fury. The judge wasn't finished. The court also awards Mr. Foster reasonable attorney fees to be paid by the HOA, as this case represents a clear overreach of authority and selective enforcement. A separate hearing will determine the amount. As we filed out of the courtroom, several neighbors approached to congratulate me. Even some who had initially sided with the HOA seemed relieved that the conflict was resolved. Karen brushed past me without a word, her attorney hurrying after her with a worried expression. I heard later that she'd called an emergency HOA board meeting for that evening. Olivia suggested we celebrate with dinner. You stood your ground and won, Sam. That deserves at least a good steak. Over dinner at Springfield's Best Steakhouse, we were joined by Oliver and several neighbors who'd supported my case. The conversation inevitably turned to the future of Oakwood Estates. Karen's going to make life miserable for everyone after this, said George Peterson, who lived across the street from me. She doesn't take defeat well. Olivia twirled her wine glass thoughtfully. Maybe it's time for new leadership. The annual meeting and board elections are next month. Oliver raised an eyebrow. You thinking of running, Olivia? She shrugged. Someone needs to restore some sanity to how this neighborhood is governed. Might as well be me. The next morning, I received a surprising visit from Douglas Perkins, the HOA treasurer. I wanted to apologize, he said, looking uncomfortable on my doorstep. I should have spoken up sooner about the selective enforcement issues. Many of us on the board knew it was happening but were afraid to challenge Karen. Why tell me this now? He sighed. Last night's emergency meeting was illuminating. Karen wanted to appeal the judge's decision, possibly try to find other violations to cite you for. When several of us opposed this, she threatened to make our lives difficult too. That's when I realized how toxic things have become. Douglas explained that he and 3 other board members had resigned on the spot, leaving Karen without the quorum needed to make decisions until new elections could be held. The HOA attorney also quit, he added. Said he couldn't continue representing an organization that was clearly violating federal law and acting in bad faith. News of the mass resignation spread quickly through Oakwood Estates. Yard signs began appearing supporting Olivia's candidacy for HOA president, along with a slate of reform-minded neighbors for other board positions. Their platform was simple: fair enforcement, transparent governance, and community input on major decisions. Karen didn't go quietly. She launched a counter-campaign focused on maintaining property values and neighborhood standards, implying that any relaxation of rules would lead to declining home prices and undesirable elements moving in. Her rhetoric only served to alienate more residents. The night before the election, Olivia and I sat on my back porch watching the sunset. We'd grown close over the months of battling the HOA together, our friendship deepening into something more. "Win or lose tomorrow," she said, "I'm proud of what we've accomplished." People are engaged in neighborhood governance for the first time in years. "You're going to win," I assured her. "The neighborhood is ready for change." The election meeting had the highest attendance in Oakwood Estates history. Residents packed the community center, with some standing along the walls when seating ran out. The tension was palpable as Karen called the meeting to order, her voice brittle as she explained the voting procedures. When the votes were counted, the results were decisive. Olivia won the presidency with nearly 80% of the vote, and all of her allied candidates secured positions on the board. Karen didn't even stay for the full count, gathering her things and leaving abruptly when the trend became clear. Olivia's first act as president was to establish a committee to review and revise the covenant, with the goal of maintaining reasonable standards while eliminating outdated or overly restrictive rules. She also implemented a new system for handling violation complaints, requiring photographic evidence and review by multiple board members before notices could be issued. As for my flagpole, it became something of a neighborhood landmark. On Veterans Day, Olivia organized a community ceremony around it, inviting local veterans and using the occasion to announce a new Neighbor of the Month program that would recognize residents who contributed positively to Oakwood Estates. Karen eventually sold her house and moved to a gated community in another part of Springfield. Before she left, she approached me at the grocery store, her cart blocking mine in the produce section. "I hope you're satisfied," she said, her voice low. "You've destroyed everything I built in that neighborhood." I met her gaze calmly. "What you built was fear, not community. Oakwood Estates is healthier now. People actually talk to their neighbors instead of reporting them." She sniffed dismissively. "We'll see how you feel when property values tank, because people can do whatever they want. That's not what's happening, and you know it. Reasonable standards still exist, they're just applied fairly now." She pushed her cart away without responding, and that was the last time I saw Karen Whitfield. 6 months after the court ruling, Oliver called with news. The attorney fees had finally been settled, with the HOA's insurance covering most of the $32,000 bill. The insurance company, however, was investigating Karen's conduct as HOA president, suggesting possible personal liability for her actions that had triggered the lawsuit. Apparently, using an HOA for personal vendettas isn't covered by their policy, Oliver explained with a chuckle. They're particularly interested in those variance approvals for her family members. Life in Oakwood Estates gradually transformed. Under Olivia's leadership, the focus shifted from restriction enforcement to community building. Monthly block parties, a neighborhood watch program, and collaborative projects like a community garden created connections between residents who had previously only known each other through HOA complaints. The flagpole that had caused so much conflict became a symbol of the neighborhood's transformation. During holidays, small gatherings would form around it for brief ceremonies. Children would ask me about my military service, and I found myself sharing stories I hadn't told in years. One year after the court ruling, Olivia and I stood in my front yard, watching as a second flagpole was installed next to mine. This one would fly the Missouri state flag, a project approved by the revised HOA guidelines that now explicitly protected properly displayed flags while establishing reasonable standards for flagpoles. From flagpole rebel to neighborhood tradition, Olivia mused, slipping her hand into mine. Not bad for a year's work. It wasn't just the flagpole, I replied. It was about standing up for what's right, even when it's difficult. As we watched the new pole being secured, several neighbors joined us, bringing folding chairs and coolers of drinks. What had once been a symbol of division had become a gathering point for community proof that sometimes the fights worth having are the ones that bring people together in the end. That evening, as the sun set behind our twin flagpoles, I reflected on the journey. My stand against an unreasonable HOA rule had cost me time, money, and temporary peace, but it had given me something far more valuable: a true sense of home, a community that respected individual rights while working together for the common good, and a partner who shared my values. The freedom to display the American Flag Act had provided the legal foundation for our victory, but the real triumph was in reminding our community what that flag represents: liberty, justice, and the courage to stand up for principles that matter. In Oakwood Estates, those weren't just abstract concepts anymore, they were the values we lived by, one neighborhood meeting at a time.